We are back, and today we are digging into a 97-page tome of an investigation into the ethics challenges at the Supreme Court. It's a document released by Senator Dick Durbin's Senate Judiciary Committee staff. It dropped on Saturday morning, the Saturday before the holidays, December 21st. It's a comprehensive overview of a year and a half of shocking scandal and corruption at the Supreme Court that I think reflects both the importance and urgency of the corruption crisis at the court and the serious shortcomings of the Senate Judiciary Committee's approach to that crisis. And you can see it right there in the title of the document, calling it a report into the investigation around the ethics challenges at the court. I mean, is that a euphemism if I've ever heard one? Lisa and I wanted to dig into this because it really does get into a lot of important stuff. But in our view, I think too little, too late, and with recommendations that provide neither accountability nor a serious pathway towards reform. Lisa, how are you digesting this? This big wrap up of Durbin's investigation.
Well, I do think it's an important document to have this issued by the Senate Judiciary Committee and to have the details that the staff and the senators put into that report in one place to help guide, future investigations and future accountability work. I think it was. There's no doubt it was a lot of work to do. I, of course, wish that it had come out sooner to be part of the national debate earlier this fall, as people were talking about the crisis we face. And I also agree with you that, the idea that these are challenges is actually distinct from what the report shows, which is that there were numerous violations of federal law by sitting Supreme Court justices. That's the headline. The U.S. Senate Judiciary Committee has documented and confirmed numerous violations of federal law by sitting justices on the highest court in the country. It's no wonder that the public's confidence has plummeted for the Roberts Court because of scandals like this, and obviously also because of the extreme decisions that John Roberts and his fellow Republican appointees have been issuing. But this report, I hope, will help provide a foundation for further action. And one thing I would note that I feel like is particularly positive is that the report specifically discusses on numerous occasions impeachment, because I think ultimately, in my view, that's one of the things that should happen when we have a Congress willing to act, is that I think that Justice Thomas certainly should be impeached.
Yeah, no question about it. And that was sort of verboten to talk about. Certainly at the Senate, we were thrilled when Representative Alexandria Ocasio-Cortez had the courage to introduce those articles of impeachment, not just against Justice Thomas, but against Justice Alito for his brazen partisanship in waving those insurrectionist flags outside of his home while sitting on those cases and refusing to recuse. And of course, this report does get into it. I think it's worth spending a little time actually digging into the contents of this report. As you mentioned, it talks about impeachment. It goes through the modern history of Supreme Court ethics and previous instances of justices, crossing ethical guardrails. And then it has this, detailed overview of misconduct by sitting Supreme Court justices and importantly, of Justice Scalia, who really established, in the words of the committee, this practice of accepting gifts of luxury travel and failing to disclose it under federal law, using this loophole of personal hospitality that Thomas then really perfected through these, luxury vacations he was taking to Indonesia and the like on the dime of Harlan Crow. But, they go through line by line all of these instances. Thomas's failure to report the sale of his Georgia properties and his wife's income from the Heritage Foundation, and his forgiven RV loan from a health insurance magnate, and the tuition payments provided to his grandnephew, and then Alito and the trips he took to Alaska, paid for by Paul Singer, and the infamous defense that Alito provided about how the seat on Singer's private jet was going to be unused otherwise, so it might as well fill it. It would be a shame to left that seat go unused on the private jet. And so, just sort of all together, and then there's way more than that, right? All together, it really paints this picture of an unprecedented abuse of power, entanglement between justices and billionaires who have real interests before the court in the cases that come up before the court, and where those interests are often the subject of conversations, of seminars that the justices are attending, such as the ones, I know you, Lisa, have been really instrumental in helping to uncover around the end of Chevron doctrine and the assaults on the American regulatory state, the regulations and the public agencies that really protect Americans' day-to-day well-being.
Yeah, that was a great summary, Alex. And I guess I would just add a couple of points for emphasis. One is, as you point out, the sort of grift of Justice Antonin Scalia is truly astonishing. It's quite clear that basically he was soliciting private vacations from people he barely met or had just met, or from someone who he asked to be introduced to in order to get a free trip. It's gross. It is disgusting for a person who is sitting at the top of the justice system at the Supreme Court to be engaging in such transactional relationships in order to get free hunting trips. And those hunting trips weren't just the luxurious trips at these plantations in the South and other luxurious, resort type places. They were also places where he was rubbing elbows with captains of industry, with political leaders, and in duck blinds and other places, like talking with them. And we know from the reporting from ProPublica a couple of really key things about that for Scalia in particular. So one is this Senate report talks about how one of the early trips that's documented by ProPublica that Justice Scalia took was back in 2004, and it was funded by a man named Rob Arkley, who was the person who provided the seed funding for the Judicial Crisis Network. And on that luxurious salmon fishing trip with Antonin Scalia, Rob Arkley talked about how upset he was that some of George W. Bush's judicial nominees were being filibustered. And he asked about whether there was anything that could be done to kill the Democrats' ability to block these judicial nominees. After that trip, Rob Arkley funded ads against Tom Daschle, who was then the leader of the United States Senate, that helped defeat Tom Daschle in that 2004 election. And also that same year in 2004, at a dinner with Antonin Scalia and Leonard Leo and a woman named Ann Corkery, Rob Arkley helped conceive of this idea of this thing called the Judicial Crisis Network, then the Judicial Confirmation Network, which was launched that Christmas after the presidential election. And that group that Rob Arkley provided seed money to was used to fund the effort to put John Roberts and Sam Alito on the U.S. Supreme Court. So these aren't just like trips with drinks, although that would also be in violation of the ethical rules in terms of disclosing gifts and, like you said, taking trips on private jets that absolutely have to be disclosed because they're valuable things. But it wasn't just the trips. There's also an undercurrent of how Justice Scalia was in those moments with those billionaires discussing substantive issues that are significant political issues, and that these billionaires bought access to one of the Supreme Court justices on the United States highest court to basically talk with them about political issues.
Lisa, I'm really glad you brought up Arkley. He features in this Senate report, and I think the encounter between the committee and Arkley is a little bit of a distillation of the shortcomings of Durbin's investigative approach here. From our experience as advocates working on these issues on the outside, really pushing for forward-leaning, aggressive oversight and the use of compulsory process, including subpoenas, to get to the bottom of the full extent of this corruption, we were frustrated by Durbin's unwillingness to do this, both to really go after the billionaires that were funding this scheme, go after the operatives that were helping to orchestrate it, like Leo, and certainly to go after the justices themselves. And with Arkley, there was this whole, procedural fight over subpoenas and whether he would be subpoenaed. Ultimately, Durbin did issue subpoenas. He issued one to Harlan Crow and he issued one to Leonard Leo. Leo, of course, defied it immediately, and Harlan Crow was able to negotiate his way out of actually having to respond to the subpoena by handing over some information. And even as we walk through that large compilation in the report of all of these findings, most of that stuff was sort of publicly disclosed stuff from investigative reporting. That was things that, those were incidents that investigative researchers and reporters found out. There are a few new trips that Crow voluntarily provided here. But Arkley was going to be one of the targets of the subpoenas, and he was able to wiggle out of that subpoena by providing some information, apparently to Chair Durbin's satisfaction, that got him out of that. But it just makes you wonder, like if this is what Arkley is willing to hand over, what Crow is willing to hand over voluntarily, what did they hold back? What did we not? Because Durbin was afraid, effectively, of picking this fight, and to make Durbin's points clear here. He raised questions about whether he would be able to enforce these subpoenas. I think there's real questions about whether they would have been able to enforce them in a civil proceeding. That would have needed votes of the full Senate, but those are votes to our minds that he should have pushed for, right? And we should have seen where the votes were cast and who was going to stand up for these billionaires and who was going to pursue real accountability. And then, with Leo defying the subpoena, that's a real criminal violation. And we've seen examples where Republicans issued congressional subpoenas, and when people didn't want to comply with them, they pursued them. They pursued criminal referrals. And that's something that Durbin could have done unilaterally as the chair of the Senate Judiciary Committee, referred Leonard Leo's criminally defiant refusal to comply with a valid congressional subpoena to the Justice Department for criminal prosecution. So, even as they sort of help bring to light some of this important content, we see the shortcomings. We see the unwillingness to press the line in terms of doing hard politics, picking hard fights against the wealthy and powerful.
Yeah, I mean, I really appreciate the points you made, and also about the potential criminal liability that Leo could have faced if the Senate Judiciary Committee had pursued it. And I agree with you that these sorts of votes, just, they had the majority in the Senate, they still have the majority in the Senate, but they could have forced a vote. And then those members of the Republican Party would have to cast their own vote, saying whether they're going to stand behind this sort of corruption and allow it to go uninvestigated, unpursued by subpoenas. And there could be consequences for those votes, rather than just have it be like a rhetorical conversation or rhetorical defense in the Senate Judiciary Committee. But I guess there are a couple of things about that I also want to build on what you said, Alex. One is, I would be completely shocked if the Judiciary Committee received 20 years of records of the money that Arkley was spending to help capture the court, to help pay for these trips, because the trips we know about include that 2004 salmon trip with Scalia, and also, as the report documents, 2008 trip with Sam Alito after the group that Rob Arkley created, the Judicial Crisis Network, helped get Alito on the Supreme Court. So just 2 years after he's confirmed, he goes on this fabulous trip with wine that was described as costing $1,000 a bottle, although Alito disputes that. But come on, this was a trip that wasn't just funded by Rob Arkley, who's the heir to a lumber fortune and who got rich with foreclosures of Californians and others. It's also a trip where Paul Singer was on that trip, and he's a billionaire who has had business before the court and was trying to get a major case involving his financial interests before the court, and ultimately did, as you and I and our colleagues have helped document at supremetransparency.org. But Leonard Leo was also on that trip. And so was another federal judge, Judge Randolph, who has deep ties to this right-wing network. And that trip was really fully investigated by reporters, not fully investigated by the Senate, because there wasn't a hearing about each and every one of those instances, there wasn't a dedicated hearing, there wasn't the compulsory process, because there are documents. It's not just like taking someone's word, or maybe, someone like Harlan Crow, another billionaire who inherited his wealth and, has a lot of real estate holdings. There are documents about how many years, for example, Harlan Crow paid for the tuition of Thomas's legal ward. There are documents showing how many improvements Harlan Crow actually made to the property that Thomas's mother still lives in Georgia for free. And there are documents that would show this issue of the fact that Clarence Thomas, kept a super low value on his financial disclosure forms for that property in Georgia, and then suddenly, right before he sold it, the value bloomed, and he claimed through his proxy that he had to renovate the property for Harlan Crow to buy it. Like, where are the documents? I mean, that is facially false, that like his billionaire buddy, who's a real estate magnate, would require him to invest in renovating the property of his mom before he would take it over. That's the assertion. But there are documents that would show how much money was spent, what was the value. And similarly, like you said, Alex, the idea of Alito that the private jet seat has no value because it was going to go unoccupied, like it couldn't be sold on the free market, is not where the value lies. The value lies in the benefit to that justice, that he gets to ride in the lap of luxury off to a fancy resort, this salmon fishing, escapade. And so we just have egregious, flagrant violations by Alito, by Scalia, by Thomas, and no consequences for them. And I hope that you and I and others can join together to really ensure that there are legal accountability consequences for these just gross, these base violations.
Yeah, we're not going to give up on that, and that takes us, I think, naturally to this section at the end on recommendations, and they do identify some of these further investigative steps needed. But a lot of the further investigative steps that were needed were ones that they could have pursued. Another subject of this report, of course, is the absurd legal arguments that Justice Alito offered in defense of his unwillingness to recuse from the Trump cases after being caught flying those flags. Again, a brazen violation of federal recusal law. And that was a fact pattern that had so much opportunity for real investigation that was just never pursued by this committee. For example, he had a whole story about the timing of when his wife allegedly flew these flags outside of his house, and it relating to a squabble over the election with these neighbors who were putting up signs outside their house that were intended to shame him. One of those neighbors went on MSNBC and contradicted his factual timeline. So that was a witness that Durbin could have called to testify at the committee. They could have sought interviews, at least private interviews with that neighbor, to go on the record to contradict what Alito was saying, to at least flesh out that factual dispute. And they didn't do it. And that really is reflected in this section of really forward-looking, reform-oriented recommendations. The need for Congress to establish an enforceable code of conduct, and other reforms related to judicial ethics. And yes, it's true, the Senate did make some efforts to pass ethics reforms bills this year, but they didn't really push the issue again, right? Senator Whitehouse has his Supreme Court Ethics, Recusal, and Transparency Act, which would improve a lot of these conditions. And rather than put that up for a tough vote on the floor, and again, see where the chips fell, they tried to pass it through unanimous consent, which is a procedure available in the Senate, where you could pass a law, but it requires that nobody object to the unanimous passage of a law. They knew that Senate Republicans would object, and that was the end of the fight. And so much of this here is focused on reforms that the Senate Democrats don't have any tangible plan or strategy to actually achieve, or votes they're unwilling to force, and so little focus on accountability, on taking these fact patterns that they have now established in this report, which they themselves conclude are legal violations with real punishments under the federal law, and actually pursuing that type of accountability. I think there we see like a real distinction between the way that Democrats in this political era would approach a question like this and how Republicans would.
Well, that's right. And this is a case where hardball, is really a necessity, because this isn't just some political dispute. It's a real issue of the integrity of the court, or the lack of integrity of some of these justices, not only in their actions in soliciting and, cozying up to these billionaires in order to get these luxury trips, but also in the deceit and the lies that they've put forward, either themselves in the case of Sam Alito, or through their proxies in the case of both Alito and Thomas. Claims that are just, absurd on their face, like that claim about, renovating the house in Georgia. But the fact is that there could have been a series of hearings to really demand that they come and testify, or other people come and testify about them, just like the case of the flag, which was also, Alito's timeline was also refuted by an actual police report to the contrary of his claims about the timing of that incident. Or the incidents around that. And so there's a lot more that could have been done, and there's a lot more that I think should be done in the future. But it's also the case that Congress has the power of the purse. They can't cut the salary of the justices right now that they're sitting, but they can do a lot of other things in terms of the funding for the Supreme Court to continue this recalcitrance that John Roberts has spearheaded. This thumbing his nose at the importance of this co-equal branch in investigating and helping to maintain the integrity of the judiciary, because these justices under our Constitution are only allowed to serve, when they're acting with good behavior. And this, by definition, is not good behavior. And so I think this is a great wrap up of this report. I hope we can dig into it again, because there are definitely more details about Chevron and the alteration of, federal laws that protect our health, our public health, and more. But I know we're going to wrap. And I just want to say, thank you, Alex, for being part of this conversation with me, and for me having the chance to be with you on Legal AF and Midas Touch Network. Please subscribe, please share, and please come back.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel, where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.